Hello and welcome to today's webinar. Take the anxiety out of demonstrating HIPAA compliance. My name is Andy Nieto and I'll be your host for today's webinar, and thank you for taking the time out of your day to join us. This presentation is being brought to you by DataMotion, a leading provider of email and file encryption solutions. Joining me in today's presentation is, today's webinar is security and privacy expert Mr. Chris Apgar. Chris is a CISSP and is also the president of Apgar & Associates. I am a healthcare IT strategist with DataMotion, where I promote and expand the knowledge of secure communication and secure messaging across all aspects of healthcare. Today's webinar is being recorded and will be made available to you after the webinar. We will also have time at the end for any questions you might have. On your GoToMeeting screen, you'll have an opportunity to put in the questions in the console. If you have any difficulty reading or viewing any of the slides, please click on the Enlarge slide button on the slide presentation screen. If you have any technical difficulties with the broadcast, please go to the webinar technical support. For more information about DataMotion, visit www.datamotion.com. We'd like to begin our broadcast today with a poll question. If we could put the poll question up, please. How prepared are you for a HIPAA audit? Are you ready to go? Some work still to do? Just got started? Not ready at all? Or haven't even thought about it? Give you a few minutes to answer that question. Couple more seconds to answer that question. And it looks like most of a couple more people still to vote. We'll close it in just a second or two. All right, let's go ahead and close down the polling. And it looks like about 65 of you say some work to do, 14% are ready to go, and 5% of you say you have not even started thinking about it. So I'm glad you're here today. I hope to answer your questions. But to start things off, let's go ahead and pass it to Chris. Chris, take it away.
Thank you very much, Andy. I'd like to thank everybody for attending today's webinar. And let's see if I can actually get the slides. There we go. The part of the webinar that I'll be talking about is I'm focusing more sort of what I would call the nuts and bolts of what you need to do. Talk a little bit about the culture of compliance, which Andy will elaborate on a little bit later. What are some of the first steps, looking at the risks, how do you make a plan, and a little bit about documentation, and then testing as far as things like your incident response plan. Now, in 2010 and 2011, the Office for Civil Rights went around the country on their little road show, and they talked about culture of compliance. And they were talking about when the enforcement penalties begin, and this was actually expanded on in the omnibus rule in the preamble, and they basically said if it's not willful neglect, then we'll take it easy on you. We're not going to go to formal enforcement. But if it is willful neglect, we will move to formal enforcement, which means civil penalties and potentially corrective action plans. The investigations, OCR is ongoing doing that. We have yet to hear anything about when the actual audit, the second round of audits, are going to occur. But what they're going to look at is OCR is focusing on those top areas of compliance that were issues that came out in the pilot audits, and also what they were preaching around the country when they called their culture of compliance. Now, the top 6 areas, and initially the incident, let's see, that's only 5. Wow, I can't count today. The top 5 areas that the Office for Civil Rights focused on in their culture of compliance were risk analysis, policies and procedures, workforce training, audit controls, and that's looking at your audit logs, things like that, and security incident and breach notification. And there was an added one, and this is the 6th one. This wasn't part of the culture of compliance, but it is added last year. There's been a pretty heavy emphasis on encryption of especially mobile devices and portable media, and also in email. So those are things that are going to be focused on by the Office for Civil Rights. Now, enforcement activities, these are some of the things they've added to the list. We talked about encryption. One of the other things added to the list is web security, because there have been some incidents where we've resulted in civil penalties or monetary settlements where a web application was not secure. I think one of the classic examples was the cardiology group out of Phoenix, and their scheduling system was basically open to anybody who wanted to look at it on the internet. Now, what are the first steps? What are the first things you need to look at? Is first you need to say, what are the risks? First you need to do is assess your level of compliance and make a plan. Because especially if you haven't done anything or you haven't done anything in quite a while, because I run across every now and then I'll run across an entity that hasn't updated their policies since 2003, but a lot's changed since then, is you need to make a plan. So a compliance plan or a mitigation plan, some of the things we need to focus on are privacy, security, breach notification, and enforcement. And there's some handouts I'll talk about in a few minutes that will help you with this particular process. Now, if you're a covered entity, you need to focus on the whole privacy rule, other federal privacy laws, state privacy laws. There's a patchwork of privacy laws across the country and in the different states depending on where you're at. And those are things that you need to focus on, whether you're operating in a single state or you're operating in multiple states. You need to look at what are all of those requirements, rather than just saying, hey, we're going to focus on HIPAA and HIPAA only. It's focus on all of those things that you need to be prepared for when it comes to, in this particular case, the privacy rule and privacy laws in the states. Now, business associates, they need to focus on the use and disclosure provisions of the privacy rule, other federal privacy laws, and state privacy laws. When you're looking at the privacy rule as far as business associates are concerned, there was a narrow focus on what they needed to do. It also included the business associates need to pay attention to supporting covered entities when they're responding to individuals' requests for things like a copy of their record or an amendment, things like that. So that's something that's also in there, as well as minimum necessary. The other things you need to look at are what are your contractual obligations that may be more stringent than HIPAA. As an example, if you're working with a state in a Medicaid program, oftentimes the states will have either regulations that they put in place, or they will sometimes it'll be in the contract. A good example of that is in the state of California, the contracts with Medi-Cal are much more stringent as far as things like breach notification than the state laws of California are. Now, as far as the security rule is concerned, covered entities and business associates, you need to focus on the whole security rule and the state breach notification laws. There are 47 states that have breach notification laws on the books, and they vary widely as far as what is considered, like as an example, personally identifiable information, and what do you have to do in the event of a breach. And this is something to really pay attention to, because under HIPAA, the business associates, if they have a breach, they notify the covered entity who does the risk assessment, and they also do the notification if it's necessary. On the other hand, under some state laws, business associates don't have that ability. They have a requirement in and of themselves to notify individuals. Now, they may do that in conjunction with the covered entity, or they may basically delegate it up to the covered entity to do that notification, but it's something you probably need to know about before you start moving forward. Again, don't forget your contractual obligations, especially if you're a business associate. A lot of times I see business associate agreements that are more stringent than the HIPAA security rule, then because of things like I better notify the individual, or excuse me, the covered entity within 5 days instead of 60 calendar days. So there's some things that you may want to pay attention to in your contracts. Now, after you've taken a look at what are the regulatory environments or the contractual environments, what is the environment I'm working in, you document that, you take a look at it, and then you say, what are the gaps? What are the things that we need to do but we're not doing? It's a good idea to start with your high-level risk assessment and identify those areas of high risk. Those are the things you need to start working on right now. And we had a conversation yesterday with Andy and I, and we were going through the slide. And one of the things that Andy had indicated is that it really is way past late as far as looking at compliance, because if you look at it, the security rule, or excuse me, the privacy rule was final in 2003, 12 years ago. The security rule was final in 2005, which is 10 years ago. Now, the Omnibus Rule and the High-Tech Act made a few changes, but the basic structure, especially on the security side, has been with us for quite some time. So I don't think OCR has a lot of patience anymore for this, or the non-compliance side of things. You need to document, you assign responsibility and resources, and assign a compliance date. So in other words, if you have, say I haven't conducted my risk assessment or I haven't updated my policies and procedures in a long time, that would be a discrete task. You'd assign who's going to do it, when they're going to get it done, because this is all part of due diligence. It's also good project planning so that you know what you need to address and you can do it in an organized fashion. So you're demonstrating due diligence, you're also creating that project plan that you can work from. Now, start with the basics. With the privacy rule, the high risks are you're looking at individual rights, you're looking at the use and disclosure of protected health information, minimum necessary. Now, if you're covered entity, if it's treatment related, minimum necessary doesn't apply, but it applies to everything else, whether it's a business associate or a covered entity for payment and healthcare operations purposes. You need to look at standard safeguards, because under the privacy rule, while the security rules only deals with electronic protected health information, the privacy rule has a section of administrative standards that you need to put in place, and that's securing everything, including paper, voice calls, any form of PHI needs to be protected. These are some of the 4 areas that were noted in the update after the pilot audit. That these are areas that were high-level deficiencies that were seen by the Office for Civil Rights during round 1 of the audits. Other basics on the security rule side, risk analysis and risk management program, especially if you're going after meaningful use. If you're going after meaningful use dollars, you need to do the risk analysis within the attestation period, not after, because if you get audited, and believe me, there are a lot of audits going on meaningful use, and if you don't have it, you haven't done it in a timely manner, they will ask for their money back. You need to look at your policies and procedures. That's another education form. If your employees don't know what they're supposed to do, and it's not defined in the policies and procedures, it's likely they won't do the right thing. Workforce training. It's more than just sitting them down in a room, plugging in a PowerPoint presentation or an internet program. It's an ongoing process, like things like bringing up headlines in staff meetings, or it's doing something fun, like putting up fun posters that remind people about what their privacy and security requirements are. Audit program. One of the things that is in the preamble to the Omnibus rule is the Department of Health and Human Services was very clear. They said, if you maintain audit logs and you don't look at them, that's willful neglect. And there are 4 different types of things to look at. You have information systems activity review, which is things like your firewall, your network, things like that. You need to look at user logon monitoring. Did somebody log in, say, at 2 o'clock in the morning and they're an 8 to 5 employee? That's a red flag. You have audit log review, such as with an auto adjudication system, electronic health record, places where somebody may be accessing so you can validate that that access is appropriate. And then finally, there's an evaluation, which is sort of an annual compliance assessment that you need to conduct pursuant to the security rule. And then finally, security incident response and breach notification. I see a lot of deficiencies in security incident response. A team hasn't been appointed, no plan has been put in place, the plan hasn't been tested, and so forth. So it's something that you need to pay attention to before that breach occurs or that security incident occurs. Now, the other high-level security risks, secure email, mobile devices, BYOD. BYOD is probably one of the more significant risks to healthcare entities in this country and probably around the world. If you basically open the doors and say, hey, you can use your personal device for work purposes, but you don't do anything further than that, you don't have any way of enforcing things like device is lost. You can automatically wipe that device and all the data on it. You can't really control that information. Somebody quits, how are you going to get your data back? So that represents a very significant risk. And we've seen last year there were a couple entities, between the 2 of them, they were fined about $2 million solely because of lost laptops that weren't encrypted. Document maintenance. If something happens, we say you are one of those lucky few that get targeted for the round 2 audits. If you don't have the documents, because initially it's going to be a desk audit, they're going to rely solely on the documentation you provide. If you don't have the documentation, you cannot demonstrate that you are compliant. This is going beyond informal policies and actually have them written down and formalized. Another area is disaster recovery and business continuity planning. We see it around the country, places where there's floods and things like that, and sometimes people aren't prepared for that. It's also looking at it from the perspective of breach. So if somebody comes in and there's a significant incident that takes your whole system down, like what's called a distributed denial of service, where they just bombard your network to the point that you can't access anything outside of it, you're likely going to kick in that disaster recovery and business continuity plan. What are you going to do about it? That's something that you may need to make sure is in place. Another area of risk is social media. People need to know what they can and can't post on places like Facebook, and they also need to know that those rules apply whether they're at work or they're at home, after hours, or even after they quit. They need to know what the program is, and it's a good idea to have a formal social media plan and a policy and training associated with it so your employees know what they should and shouldn't do. Now, a couple of handouts that were included, and you can download these, is there's a sample compliance planning agenda. That's something that you can use as a tool where you can walk through that process that I talked about as far as building that compliance plan. It's an agenda that takes you down through the steps, things that you need to look at, and it has a sample of what would be sort of the starting place for that compliance plan, where you have, say, I don't have any encrypted email. That's one of the tasks. Who's assigned to it? What are the resources necessary? How long is it going to take? That's all there as a framework for you to use. The next is sort of a checklist. It's just taking a look at what are those high-level things. I focused on some of them, but there are more to pay attention to. Those are two of the documents that you can download and use in your own organizations as you are moving forward with your compliance planning process. Whatever you do, you need to document, right? Emphasize that around the audits, but it's also one of those that you need to document so that, a good example is I have a security incident. I need to document that that incident occurred and what did I do about it. It doesn't necessarily mean it's a breach. Go back to that distributed denial of service that I talked about. That will shut you down. That's a security incident, but it's not necessarily a breach of information. So you need to pay attention to that. Another one that's big out there that is a security incident, not necessarily a breach, is ransomware. Well, somebody will infect your system, they will encrypt your data and say, if you pay me so much money, I'll give you the key so that you can unlock it. That, unfortunately, is becoming more and more common. So when you're looking at your compliance plan, you need to look at what is being mitigated. This you can refer back to that handout that I talked about, the planning agenda. What do I need to mitigate? Who owns it? What are the resources? And it's not just like with secure messaging, buying the tool to secure your emails. It's also making sure you put in place or you document what amount of time is going to be necessary from staff's part so that they can work it into their workflow, and that way you can document, who's doing it, how much time is it going to take, and how much money is it going to cost. Some of these tasks aren't going to cost you any money, but it will cost a significant investment in staff time. And then you also need to make sure you have a timeline for completion. So if you're in the plan and if you find that things are slipping a little bit, you're not able to make that date, update the plan. And then when you finish the task, update the plan and say, hey, it's been done. And that way you also, this gets back to the due diligence piece, where you can demonstrate that you've actively worked on it and you completed those compliance tasks. It doesn't all need to be fixed today, but plans need to be reasonable. And at this point in time, as I mentioned earlier, we're getting to a stage where the Office for Civil Rights is not going to have a lot of patience with noncompliance, given the fact that we're looking at rules that have been in place for 10 years or more. Keep the plan up to date. So when I talked about timelines, they slip, they change, make sure it's documented, put it in that plan. It's also a good idea to make sure that you store all of your documentation centrally. Your policies and procedures, your plans like your incident response plan, your disaster recovery plan, your business associate agreements. Keep them all stored in a central place so that you can get at them quickly. If there's an investigation, if OCR, they say they get a complaint or a breach occurs that's 500 individuals or more, OCR will likely investigate. And I can tell you, like with a breach, if you get that letter from OCR because you had a larger breach, you have a 500 or 600 person breach, you get that letter from OCR, they're going to ask you for a copy of risk analysis, all of your security policies and procedures. What did you do to mitigate the risk, and what did you do to make sure that this isn't going to happen again? That's some of the things that, I think I slipped my slide, there we go. You need to make sure that you have all of that in place so that you can hand it over. Audits, and that could be the OCR audits. That's going to hit a small number of entities in a random fashion, so you don't know if you're one of the ones that are going to get hit with that. The other audit to pay attention to under meaningful use is the fagiosity audits. Those are occurring on a pretty regular basis, and it is likely that if you go after meaningful use dollars, at some point you will be audited. So you need to be able to prepare that information and have it centrally accessible. In the case of civil actions, under the Federal Rules of Civil Procedure, under e-discovery, generally you have 30 days. If you get a discovery order that says here are the things you need to produce them within a certain period of time. Otherwise, the courts get sort of angry at you, and they do things like say, okay, well, the plaintiff can go on a fishing expedition and look at whatever they want. And that's not something you really want to do. Now, as far as the document, when you're mitigating, make sure that's documented. You look at your audit logs on a regular basis, make sure that's documented. Even if it's, I took a look at the audit logs, nothing popped out as an anomaly or something that looks suspicious, document the fact that you did that. You're monitoring your security incident investigations. All of that stuff needs to be documented. And the other thing you need to remember, it also needs to be retained for 6 years. Now, when you get into document retention, it's always a good idea to only keep it as long as you're legally required to keep it, because the longer you keep it, the greater the liability. It's all discoverable. If there's a sound business reason to retain it longer, that's a good idea to go for it. Just document it in a document retention schedule that this is how long you're going to maintain it, and then after that point, religiously destroy it. Then don't forget to test. Plans usually don't work unless they're tested ahead of time. Not a good idea to test the plan when the disaster hits or you have a big security incident. So you have your security incident response plan, good idea to test that on a regular basis so that you can make sure that the team knows what they're supposed to do and how they react. And then if new members come along to the team, the same thing, is they get an education on what they're supposed to do. Disaster recovery, business continuity, same thing. I know that there are regional events where they do emergency planning and big tests and things like that. Participate in those so that you can exercise your own plan and see if it will work for you. And this isn't just a one-time event. You say you put your security incident response plan in place, you test it the first time, you never test it again. Times change. People come and go. Risks change. The types of breaches that will occur change. Same with disaster recovery and business continuity. You need to make sure that those are done more than once a year and updated as needed. Now, a lot of organizations, they only test their disaster recovery and business continuity plan on an annual basis. That's okay. As long as you document it, you do it. Security incident response is a good idea to test it a couple times a year so that you can make sure everybody's prepared and that the plan works. You're never going to be able to plan for every eventuality, but you can plan for a whole lot of things that may go wrong so that when it does come up, and if it does come up, then you've got an action plan and that you know it works. Now, in summary, as far as what the areas that I'm going to talk about is if you have the gaps, those gaps, the time to start addressing it is right now. Compliance is not a one-time event. It's something that's an ongoing process. And Andy will talk about culture of compliance more, but that's what it becomes. It's you're creating a culture of compliance within your organization, and you're not just focusing on what's internal to you. You're looking outside, those key vendors that help you get along. Whether your business is a covered entity, you likely have some key critical vendors that you want to make sure that they're compliant and that they've got sound security and privacy practices in place. Biggest risk, top of the list, is people. When you look out there, yes, we've had some very, very large breaches that have involved millions and millions of folks. If you look at the sheer number, though, the breaches that occur, not the count, not the number count of individuals involved, but the sheer number of incidents that are breaches, more often than not, they occur because somebody didn't do the right thing. I recently ran across a poor client who their IT manager, who was head of IT, had his laptop with him. It's unencrypted. He went to the gym, and he left it in his backpack in an unlocked area, and somebody stole it because it was there. And that resulted in a pretty significant breach. That was a people problem. That wasn't an issue with the technology or anything else. It was a people problem. You need to make sure that they're fully trained, and then they're trained again. So training is not a one-time event either. You also need to make sure you can respond quickly if OCR calls. I can tell you that if, say, somebody files a complaint, OCR, what they do is they look at it and they say, okay, is it within our jurisdiction? If the answer is yes, they take the next step and say, is this somebody who's sort of an off-the-wall complaint? Those they'll dismiss and get back to the individual and say, yeah, I'm not going to look at it. Everything else, though, OCR does investigate. It may take them some time, but you can't expect a letter from OCR if somebody complains saying, okay, this is the complaint, prove to me that that complaint is not valid. And that gets around to that centralizing your documentation, making sure it's there, making sure people are trained, and so forth. Now, here are a few resources for you. There's some good information from the Office for Civil Rights on privacy compliance for covered entities and business associates. There's also information about security compliance. If you want to look at a model, notice of privacy practices, if you're a covered entity, there's a great model out there that was put out by OCR. And then there's a risk assessment tool that was put out by the Office of the National Coordinator for Health Information Technology, or ONC for short, that you can access, and this has been recognized by OCR and CMS as a valid tool for them. It can be a little rudimentary, but it's especially if you're a smaller entity, this is a good place to start, give you some good ideas of what you need to look at. There are also NIST documents out there to look at, the National Institute for Standards and Technology, but those are ones that are great to read if you've got insomnia. Believe me, they will likely put you to sleep. They're rather dense. Now I'd like to turn it back over for Andy to run the polling question. Polling question number 2.
Thank you so much, Chris. I appreciate it. So we are at our second polling question, and that is, how would you rate your organization's culture of HIPAA compliance? Are you black belts? You take it very seriously? Are you at business risk, but we balance it with getting work done? Or do you not really consider HIPAA? I give you all a chance to answer the question there. See, about half of you have voted. Lots of votes coming in still. Go about 5 more seconds of voting. I see about 75% of people have voted. Give everybody a chance to get their votes in. All right, let's go ahead and shut down the voting now. And so about 46% of you say you take it very seriously, and 46% say you balance getting HIPAA with actually getting work done, and 7% don't really consider HIPAA. So interesting results, and helps us guide our next set of questions. So thank you so much. From there, I'd like to get into my part of the discussion today. And my part of the discussion, we're going to specifically be looking at kind of the culture of compliance, the way things workflow. Andrea, if you want to go ahead and pass me control, thank you so much. I'm going to talk a little bit about the table stakes for dealing with PHI. I started calling it table stakes because really, with today's environment, especially what Chris has described, it's really time. If you aren't already doing it, you're behind the schedule. I'm also going to look at, if you're looking to partner with someone, or if you already have vendors, what are you looking for? And I'm going to finish up talking about a culture of compliance and security and why that's very important. So as we go through here, and let's see, Andrea, there we go. Let me go back one slide here. The first is, what is your role in the community? The reality is that if you're dealing with patients, if you're dealing with medical information, if you're an employer who has information about your employees' health care, especially if they're applying for their health insurance, it is important that you be able to leverage that technology and be a leader in the environment. Whether you're sending information or receiving information, you need to be protecting it. You need to know where it is in your organization and how it's stored. And you need to go even further and work with your vendors to be faster and smarter at addressing the technology, addressing the information, and protecting the information. This does mean you have to actually look at your vendors, look at how you're communicating with your vendors. Expect more from your vendors and demand more from your vendors. When you talk about being a business associate and being a covered entity, in many, many cases, and in fact most cases, you're actually both. You're working with others. You have vendors who share information with you. That makes you a business associate. And in your work as a care provider or a document company, you're also a covered entity. So in so many ways, you're actually both. Your role as a covered entity and your role as a business associate are very similar. They require that you be a good steward of the PHI. Being a good steward means that you have a business ethic that drives you to protect, to secure, and to maintain the information to the best of your ability. Just as good stewardship of money, of other people's money, you guard it, you protect it. We want to use the same protection for our health information, because the reality is PHI is valuable. It is as good as money on the black market. You also have some rights. Don't forget your contractual obligations with your vendors and your vendors' contractual obligations with you gives you both responsibilities and rights. You can say to your vendors, I have to hold you at this standard, this higher standard, because I'm held at a higher standard. And you, being a vendor of mine, are now a business associate, and your breach affects me. So you have rights to demand more from your business associates. Communication must be secured. We used to make this presentation and we would say things like, you need to start thinking about encryption. You need to start thinking about preparing and protecting your data. The reality is we've been doing HIPAA for 10 plus years. We've been doing protected health information for more than 10 years. We have to secure our data. To do that, you have to know where your data is, and you have to treat the data in all of its statuses. Your data at rest, where is it stored? In a filing cabinet, on a hard drive, wherever it's being stored at. When it's in use, who has access to what data when? How are we documenting who has access? Remember, Chris said a number of times, document, document, document. I'm going to repeat that. We have to know who has access to our data, when they had access, why they had access. Because if someone files a complaint and said, John Doe is talking about my health care, how did they get exposed to it? You also have to recognize data in motion or data in movement. When you're moving data from point A to point B, are you carrying a file in the trunk of your car? Is it a flash drive you're carrying around? Are you transmitting it on the internet over an unencrypted channel? How do we protect our data? Electronic data, both at rest and in motion, is best protected using encryption. It is, in fact, the de facto standard and a reasonable safeguard. Chris spoke a few minutes ago about willful neglect. Willful neglect is basically saying the technology and solutions were available to you and you chose not to use them. That's willfully neglecting the data. So my advice, just do it. Again, your leadership in your community stands out in how you are a steward of the data. Enforce, expect, and demand compliance for trading partners. And if your trading partners are unwilling to be good business associates and be compliant business associates, it's time to look for a new trading partner. This requires that you had a written policy and that you've announced that written policy to your partners, that you are engaged in your community. Are you waiting for them to do it for you, or are you saying, hey, we're going to be leaders in our environment, we are going to be proactive in protecting our data, and here is our policy that we've written down. In all things, this is a growing field. So you may have to guide them a little. You may have to educate them. As you're educating your own staff, you're going to have to educate your business partners. Hey, Business compliance to protecting PHI is critically important, and you're part of that chain of custody. Therefore, you are part of the solution. When looking at security, there is a cost. The reality is this triangle represents equilateral triangles. To improve the ease of use of something typically requires the increase of cost. To improve the security, there's an increase in cost. To improve functionality, there's an increase in cost. Security and compliance should become a budget line item in your annual budget. You should recognize its importance, recognize its business requirement. If it's a clinical office, it's no different than saying, here's our malpractice insurance, here's the cost of our clinical supplies, and here's the cost of our compliance and security, because it is a critical component of our business. Security should also fit in the workflow. I love that about 46% of you said that you balance your security needs and business risk with getting work done. I applaud that, because we have to recognize security in getting work done. As I said earlier, HIPAA is all about being a good steward of the information you gather, possess, and exchange. The HIPAA rules and regulations of security do not prevent us from sharing information with another provider for the purpose of caring for that patient. HIPAA rules and regulations do not prevent us from communicating about a patient, asking questions, requesting a consult, and even communicating with a patient's family with the appropriate releases of information. In fact, you should expect from your EHR, your technology vendors, and all of your vendor partners that the security requirements that you have be integrated into your daily workflow. And if they're not, evaluate whether that partner is a good partner. Integration in the workflow increases compliance by your employees. And as Chris said just a little while ago, and I'm going to repeat, your personnel is your greatest security risk. So integration of your compliance solutions into the daily workflow improves your likelihood of success. When we talk about integrating in the workflow, I'm going to talk about encryption in the workflow. If you're using secure messaging, is it in the same tools you would use to communicate to your inside as well as outside, or is it a separate window? In other words, can I send my secure email from Outlook, or do I have to open a portal? Can I send that lab report to the referral partner from the EHR, or do I have to print it and fax it? Anything you can do in your workflow to protect the data by encrypting it in the workflow is a plus win-win for you. Culture of compliance. Chris has said it, I've said it, you've heard a lot about it. The reality is that our employees, our teammates, our team members are the biggest risk that we have. We want to leverage not just the technology and encourage the adherence to a culture of compliance, but we want to talk to our people. We want to endorse and practice security from the top down. I was working with a practice several weeks ago, and the doctor and the nurse practitioner did not lock their laptops. They shared their passwords with their coworkers, and they just treated security like, well, that's my staff's job. And as a result, the staff was pretty lax about security. And when I explained to them that if the doctor shows as much interest in protecting the data as the staff does, that top-down approach, that culture is driven from the top. As parents, we know that if we say, hey, put your seatbelt on every time you get in the car, and then we don't put our seatbelt on, the likelihood is as soon as they become teenagers and they're driving, they won't put their seatbelt on either. Develop your security risk awareness. Now, this is kind of interesting. Developing your security risk awareness means understanding what information is moving, understanding what information you have, and understanding how Your business associates, your patients, and other providers access your information. Be aware of holes in the environment, and don't be afraid to ask for better solutions. If you've been consistently faxing to a partner, ask them if they have some kind of secure messaging platform so you can avoid faxing it. If you've been regularly printing information, putting it in an envelope, and mailing it, perhaps there's a better way to deliver that information to protect it. And look at your vendors. If you have a cleaning company who regularly goes in and it seems like every time they're in the office, something's moved, maybe you need to evaluate what they're doing when they're in the office. Being aware of all of the participants and all those who touch the data is critical to our success and critical to knowing what's going on. I jumped over my last slide here. The bottom line is you're part of a larger community. As much as we'd like to have closed walls and know that what we do inside our office is the only thing that matters, we're part of a healthcare organization, a larger community. To protect yourself, you really do need to be a leader. You need to take charge and ownership of the data and have a leading role in demanding compliance. You must develop a culture of compliance within your environment, and you need to do the same with your vendors. It's time for our last poll question. And our last poll question is, what is your likely next step when it comes to HIPAA compliance? So your choices are, do you still need to do a risk assessment? Are you in the strategy and planning stage? Are you at the point where you've done the risk assessment and now you're doing risk mitigation? Or do you feel like you're fully compliant and there's nothing left to do? Give time for everybody to answer this.
But one of the things to think about is when you're looking at this is when you're looking at these particular items, unless it's nothing, if you haven't done it, that likely falls into the category of willful neglect. So it's probably a good idea to start doing something.
All right, we have about 65% of people have put in their answers to the poll. Let's give a couple more seconds for those that haven't answered yet to put your names in, put your answers in. About 5 more seconds. And Andrea, let's go ahead and close the poll. So interesting distribution here. About 10% of you haven't done anything. 33% are at the risk mitigation phase. Congratulations. As you're mitigating risk, as Chris would say, document your strategy and planning. The documents that Chris will provide are incredibly helpful in that. And if you're doing your risk assessment, make sure you're assessing your risk in all 3 phases of data: at rest, in use, and in motion. Chris, any other comments on the poll?
No, what I would say is that if you're looking forward and you're saying what are the tasks I need to do, that's a great first step. And then it's the follow through to make sure that you get it done. And just to keep in mind, you don't need an outside vendor to come in and do this for you. You can do it yourself. The outside vendors can be helpful. And in some cases, if you're a business associate, it's going to be demanded of you by your customers that you have a third party look at how you're doing in your organization. So it's one of those to not only pay attention to, as Andy put it, the community, it's you also need to pay attention to what are the specific requirements that are pushed down on you.
Excellent. So Andrea, if you'll go to the last slide, and while Andrea does that, if you'll notice on the right-hand side of your screen in the GoToMeetings command console, you have the ability to ask a question. I would encourage you to ask as many questions as you like, and we'll get to as many as we can. Our first question comes from Sherry, and that is, how do we determine who we need business associate agreements from? Chris, do you want to take that?
Sure. In fact, there's a post that I put out on a couple of them on LinkedIn that specifically focus on, as an example, you have conduits, which is mail, versus, say, a data center that's hosting your data, and one that's specific on how do I know it's a business associate. The easiest way to look at it is if you have a vendor that you regularly use and disclose PHI to, and they themselves use your PHI for, they use it, they disclose it, they maintain it, they transmit it, then they're a business associate. Because a business associate could be a law firm for, say it's a malpractice lawsuit, it could be your CPA if they're looking at your payroll. It's not your payroll, but say your records that are have patient information. It could be a whole host of different types of vendors. The key is, do they have access to your PHI, and what are they doing with it? Before we move on, I just want to point out in the right-hand side in the GoToMeeting control panel, if you look towards the bottom, there are the two attachments that you can download that I mentioned earlier.
Thanks, Chris. So the next question is from Donna. Donna asks, for a question for you, I am a business associate that produces an EHR software. I believe the only way for a breach in our organization is via our support team, which always uses anonymous user client ID when working with our clients. I apologize, let me scroll down the rest of the question here. As long as our software is compliant, are there any other areas of concern for us? Chris, do you want to take a stab at that, and then I will also have...
I would say the answer is yes. There are other things. I mean, just because your technology is compliant, that's a great thing. But you also have to look at, you got two other areas of security that you haven't focused on. One is administrative safeguards. That's the people side of things. Your policies, your procedures, your incident response plan, those kinds of things are not technical in nature. You also have physical security, not only of your data center where you're hosting your EHR, even if it's a software as a service or a SaaS model, you have to worry about that. But you also have to worry about your own office and what's happening within the office. Because I know in some cases, like the EHR vendors that I worked with before, they'll occasionally get screenshots that will be sent to them by a client, sometimes unsecured. And it's paying attention to what do they do with that once they receive it.
Absolutely, and Donna, I'll add a couple more things, and that is that being an EHR, you're going to be held to a slightly higher standard when it comes to your clients going for meaningful use. If they suffer a breach and it comes back to your software, how did that occur and what resources have you made available? Do you have a documented plan for how your customers respond to that? Have you documented where the data is stored? How the access control is maintained? Some other things that I see a number of our EHR partners working with is access control. Who has access to what? That documentation, is that available, and is that remotely available outside of the system? You also want to be able to document release of information. If a patient says, yes, my mother can access my information, I'm an adult, but yes, my mom can access it, or yes, I'm elderly, and that yes, my adult children can access my information. How do you document that? And finally, as an EHR, you want to definitely take a leadership role in partnering with your physician and clinical practices. You want to help them develop their own business associate and covered entity plans. You need to help be a leader for them. They're looking to you as their business partner to achieve that. We have another question from, and I apologize, I'm having to scroll through, Alan. Alan has asked if we're going to be making a link to the slide deck available. Alan, yes, we will be sending out a link to the slide deck after the presentation to all the participants. And feel free, anyone, to put in more questions. We have some more time left. I have a couple other questions here. Let me pull them up. Okay, so if you could, one question here is, please talk about compliance versus best efforts versus best practice versus maintaining proper security. In other words, in an office operating procedure versus best practices versus standards. Chris, do you want to take a shot at that?
Could you repeat that? I'm sorry, I was having some problems and I missed the question.
No problem. The question is, can you please talk about compliance versus best efforts versus practice versus maintaining proper security?
Well, if you want to look at it from a compliance perspective, there are certain requirements that are set out there, that you have to follow, whether it's federal law or state law. If you're looking at that, and I always advise looking at it in a broader perspective, because you're not only looking at, am I compliant with, say, HIPAA, as an example, the security rule, you also need to look at, when you're looking at it from a practical perspective, you need to look at what works in your organization. The security rule is meant to be very flexible. So it's what is reasonable for you. What's reasonable for, let's say, a single physician practice is not the same thing as, for, say, a large health plan or healthcare delivery system or a vendor. So you need to look at, from a practical perspective, what do you need to do? And there may be cases where you're looking at information security, and you want to go beyond what compliance states you need to do. So you're looking at your environment and what do you need to do to protect yourself, your information, and your patients or health plan members. Maintenance is something, it's an ongoing process. That's what risk management is all about, is it's looking at the new risks that may come up, addressing them as they do, looking at, take a look at your policies on an annual basis, test your plans, things like that. That's part of the maintenance process that you need to go through. And it's, again, it's an ongoing type of process. It's not something that's the one-time event. So it's keeping that up. It's keeping your staff trained and up to date on the latest and greatest, as far as things like spear phishing is a good example, where you click on the wrong link and you find yourself as an anthem in the headlines as if you're really large, you've got millions of people who's breached. So that's the sort of the process. As you look at compliance, what do I need to do? Not just HIPAA, but across the board. You look at what do you need to do within your organization, and then once you put that in place, you should make sure you keep looking at it periodically to make sure that it still matches what you need and what is the regulatory compliance issue.
Excellent. So we have a question from Aleda, and that is, do you have an idea of what percentage of BAs, business associates, have completed their first risk mitigation, including signing BAAs with their subcontractors? Chris?
I would say that many of them have, but especially the larger ones, and that's primarily because it's not so much compliance as it is market pressure. They're getting the larger, especially the larger vendors, or those vendors that are working with large entities, are getting a lot of pressure these days to make sure that they can demonstrate, which would be, give me a copy of the summary of your risk analysis, show me your policies and procedures, things like that. I've seen a number of different large questionnaires that are sent out by covered entities to business associates requiring them to do that. It's also, when you're looking at it from a, like startup, HIT is this mad thing that's going on right now. More and more venture capitalists and investors are saying, you need to prove to me that you've got good security. So they're moving that direction. There's still a ways to go where a number of them really haven't done everything that they need to do. It's like you go to a website, the vendor will say, hey, we're HIPAA compliant. It just means oftentimes that their technology meets the requirements. It doesn't mean that they're doing the right thing when it comes to, say, the people side of things. And a little bit outside that question is one of the other areas that I see as far as a deficiency in this industry is on the healthcare provider side. No matter your size, the provider community is a ways behind where it should be when it comes to security, and that's all the way down to conducting that risk analysis.
Excellent. I would go one step. I'll also say that it depends upon whether you're working with a national provider or a national organization or a local organization as your BAA. And it also has to do with what kind of leadership you as an organization are giving. Are you going to all of your business associates and saying, this is our expectation, this is what we expect from you. We need a copy of your risk assessment. We need a copy of your documentation, and we need that on a quarterly, semi-annual, or annual basis to know that you are compliant. And we want to know who your subcontractors are, because the long tail of compliance goes down to them.
One of the things to keep in mind that's sort of a cautionary is when you're looking at the subcontractors, your business associates need to keep in mind that you are not responsible for their compliance. They are a risk to you. But that was one of the things that was very clear in the preamble to the omnibus rule, is you don't want to get into a position where you're managing those subcontractors. You don't want to pick up that risk. You need to pay attention to what they're doing and ask. But it's one of those, you don't want to get into the direct management of compliance when it comes to subcontractors. Make that your business associate's responsibility.
Absolutely. We have time for probably 2 more questions. The next question is from Tracy. I have a business associate agreement for all of my vendors. I am the covered entity, but all of my vendors want me to sign their BAA. Should I sign theirs and have them sign mine? I am having trouble with my vendors, especially my IT guys.
Not surprising. I advise covered entities, whenever possible, you make them sign your business associate agreement, because there's likely going to be information in yours that is going to be more stringent liability clauses, limitations of liability, indemnification, paying for the breach, things like that, that you want in there. Now, there are going to be cases, give you a couple real good examples, Google and Microsoft, Office 365 or Google Docs or Google Email. If you're using those, you're probably going to be stuck with their business associate agreements. You're not going to get them to sign yours. So it depends on how much pressure you can put to bear on them. And it goes back to something that Andy said. If they're not willing to sign up to that, then it may be time to start looking for other vendors. That's not always feasible. Like if you spend a lot of money on your EHR, you're not going to just dump them and go find somebody else. But where you can, that's a good place to say to those vendors, hey, you can either sign up for this, or there's a shop down the road that I can go to and get equal services that they will sign up.
I'll only add to that if once you have done a good risk assessment where you have well-documented positioning on what kind of data you generate, where it is, what your exposures are, it's very easy to map that out and go to your associates and say, here's the data we receive from you, here's the data we send to you, here is our risk. As the owner of that data, you need to sign, or as the recipient of that data, we will sign. So when you map out where the data is, how the information is moving, it's a little bit easier to see, do I have more of an associate role, or do I have more of a covered entity role? But always keep track of whatever information you sign, whatever agreements you sign, need to become part of your risk analysis and risk mitigation, because you now have to document to those contractual relationships you've created. Chris, you were going to say?
You also look at the size and how much impact. I mean, if it's somebody, I've got a large client, they're a big health plan, and their chief privacy officer said, you know, this particular vendor over here, they got a lot of our data. I really care about them. I got this other guy that comes in, he's a specialist, and he looks at something, he may look at a chart once every 6 or 8 months. I don't really care about that. I'm not going to spend a lot of time on that one, so it's prioritizing. It's also, when you're entering into a contractual relationship, you look at what do they have as far as information security up front, but that's not the only time. You need to do that on a periodic basis where you go back to that business associate and say, prove to me again that you're still compliant.
Excellent. Last, I think we have time for maybe one more question after this, if anybody has any last-minute questions. But Charles asks, how often should BAAs be signed and updated? I have an opinion, but Chris, do you want to take a shot at it?
As I say, when you sign up with them, you should sign the business associate agreement. They need to be updated if, oftentimes, the updates are if there's a regulatory change. And that's often the case. I mean, like with the omnibus rule, there were a lot of updates that were needed for business associate agreements. It's just a good idea to go back and look at it periodically to say that it's still applicable. It's not something that you've got to do. You don't have to update it every year or something like that. It's when things change that need to change the contractual relationship.
My only addition to what Chris has said is that when you should put the review of your BAAs as part of your annual audit, or whatever your periodic audit is, you should audit your BAAs. Do you have BAAs with partners you no longer work with? You should review your BAAs and have that as part of your regular documentation review, just like when you review your logs, when you review all of your contracts, whether that's annually, semi-annually, quarterly, whatever it is. Keep track of it, because you're also going to be held to those standards. We haven't received any other questions, so at this time I'd like to conclude our webinar, taking the anxiety out of demonstrating HIPAA compliance. And really would like to thank Chris Apgar for his valuable information. Chris is truly an expert in the field, and Chris, thank you so much for your time today. I appreciate it.
Thank you, Andy, and I hope everybody got what they needed, or at least got a start from this particular webinar.
Absolutely. If you have any additional questions, please feel free to contact Chris or myself. A recording of this webinar will be made available to you shortly after concluding it. Thank you again for joining us, and have a great day.